we generally obtain a statement from the child and any residual statements that are required as well. In relation to historical matters, essentially these matters, after the statement has been taken from the victim, there are essentially numerous avenues of inquiry that need to be pursued in relation to historical matters, as there are with recent matters, but historical matters are much more difficult because of the historical nature of the report. Many aspects of a victim's statement must be corroborated. For example, if a person states that when they were 15 years old, which may have been 20 years ago, they were a student at a particular school, school records need to be obtained. If they say that around their brother's 10th birthday it occurred, then we need to get a statement from the brother, we need to prove the age of the brother, we need to speak to other people who've been nominated as being present or near or spoken to around the time of the offending, and the avenues of inquiry can be quite difficult and protracted due to the nature of the timeframes. It is extremely important to corroborate the aspects of a victim's statement, in particular in historical matters, because it assists us in narrowing down the timeframes for when an offence is alleged to have occurred. When any person is charged, the details of the offence must be particularised, and we must, as best as possible, narrow down timeframes, locations and dates. It's important to ensure that for the matter to be heard and determined at a court and for a conviction to be obtained, that those details are very clear. From that point, once all statements have been obtained, we then determine what avenues of inquiry are remaining in relation to any particular crime scene. So photographic evidence may be required of where an offence is alleged to have occurred. These photographs would also assist in corroborating any version of events that has been provided to us by a victim. We also consider medical releases to speak to doctors who may have examined a child at the time of the alleged offending, which may again corroborate injuries that they may say that they have received at a particular time, and also psychologist statements, psychologist records, who may be in a position to provide some information in relation to alleged offending or reported incidents that may not have been to the point where things needed to be reported under mandatory reporting, but may go some way towards corroborating what is being said by the victim. The next stage of the investigation will generally be to arrest and interview a suspect. However, there are other investigative methods that I won't go into tonight. The next, as I say, next will be to speak to an alleged offender and to interview that person, give them an opportunity to answer the allegations. From that point, once the person has been interviewed, a determination will be made at that particular time whether the person will be charged, whether the person will be released pending a summons application, or whether they'll be released unconditionally. In the event that someone is charged, there are a number of options. The person can be presented before a court, the person can be bailed by the police, and if the person is released pending summons, it may be some time before a person is charged at all. From that process, the matter will be heard at there are a number of small hearings called filing. There's generally a filing hearing, a committal mention, and then the first time where a person may be required to give evidence is at a committal hearing. A committal hearing is essentially a test of the evidence to determine whether there's sufficient evidence that a properly instructed jury may convict that person of that offence. It does not determine guilt or innocence. No person is required to enter a plea of guilty or not guilty at that particular time. Following a committal, if a magistrate determines that there's sufficient evidence for a properly instructed jury to convict, the matter will be sent to the county court or the Supreme Court, depending upon the nature of the offences. The Supreme Court do have the power to hear certain serious sexual offences. However, 99% of the time they will be heard in the county court. The county court, depending upon the time frame where a victim has reported the offence, if the victim is still a child, the matter will be heard in 2 separate hearings. The child will have their evidence played from their recorded interview with the police, and then immediately afterwards they will have a cross-examination, and this is essentially, I think it's within 3 weeks of the committal hearing. Don't quote me on that. It's within a few weeks of the committal hearing, after the committal hearing, and that generally is the last time that the child will be required to give evidence. So once that hearing has been heard and determined, they are not required to appear before a jury and give that evidence. It's new legislation that's only been in a few years, and it, in my opinion, is very positive for victims. It means that in the event that a matter is heard, has to go to retrial, or if there's an appeal where the evidence is required to be heard again, it protects the victim from having to give evidence numerous times and having to go through the matter again and again and again. In the event that the child is now an adult, the child will be required to give evidence in front of a jury. However, the vast majority of the times, unless the person wishes to be in a court with the accused, the victim can give evidence via a remote witness facility where they are not in the room with the accused and they're not in a position to see the accused, which also, again, protects the victim. From there, and it's up to the courts to determine what actually occurs with the accused, whether there's sufficient evidence for a person to be found guilty. A trial judge will probably instruct, most of the time, a jury, and the jury will make a determination from there. There's a point here: why should the authorities care about actual or suspected cases of child sexual abuse from 20 years ago? Well, to me,